So is there any objection to proceeding with your plea bargain agreement under the amended plea?
Not from
No,
the,
ma'am.
All right, and the court will note for the record that the original paperwork for the plea bargain agreement was signed. The amended plea bargain agreement, where the state is silent, was not signed by the defendant. The court is calling 2023 CR 5888 State versus Anna Gifford. Can I have parties announced for the record for the state?
Brandon Brady for the state.
Robert Maurer for defendant.
And are you Anna Gifford?
Yes, ma'am.
And so the record is clear. I can be fair. I never went on a trip with Mr. Maurer. I went on a trip with his sister, and it was for international CLEs that I was the director of. So does anyone have any issues with my continuing?
We certainly don't.
Okay. All right, thank you. All right, Ms. Gifford, you entered a plea,
Yes, ma'am.
and it's the court's understanding that the state has amended the plea bargain agreement. Did you have a chance to review that amendment with your attorney, and did you understand it?
Yes, ma'am. Oh, wait.
Yes, we went over that together or not?
Yes, sorry.
So is there any objection to proceeding with your plea bargain agreement under the amended plea?
Not from
No,
the,
ma'am.
All right, and the court will note for the record that the original paperwork for the plea bargain agreement was signed. The amended plea bargain agreement, where the state is silent, was not signed by the defendant. Ms. Gifford, could you raise your hand for me, please?
Yes, ma'am.
Solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anna Gifford.
All right, do you have any objections to your attorney writing your name with regards to the waiver of appeal portion of the document?
No, ma'am.
And stated defense, it's the court's understanding that Ms. Gifford paid the entirety of the restitution. Is that correct?
That's our understanding, Judge.
that is correct, Judge, and I tendered a copy of that to the state.
All right, this is what the court will do. The court will sentence you to 6 years deferred adjudication. Oh, I'm so sorry. Odyssey is down. Just give me one moment. Yes, but it's going to be a great day.
Manifest. It's gonna go through.
Mm-hmm.
The number of times I've heard the phrase Odyssey is down in the last year. We can't complain about it.
No.
Yep. Other counties are like, why did y'all use Odyssey? You didn't know how bad it was?
Mhm.
Yes.
So now it's
Got a
taking.
kickback.
All right. It is preparing the session. All right, so, oh, I'm so sorry. State, you may be excused.
Oh, thank you.
Thank you.
I was gonna say.
No, I appreciate it. All right, Ms. Abrams, are you ready? And Cindy, are you ready?
Yes.
Okay. It says getting your case.
I'm gonna bill the county. Well, that's okay. They won't pay it anyway. The MAC will lose the voucher. Auditor will forget to sign it. Bethke's running for DA though.
Okay, so it's going to be 8 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Which county are you in?
I'm located in Augusta, Georgia. Richmond County, I believe, or Columbia County.
All right, I'm just gonna say transfer to Augusta County. I'm sorry,
Okay.
to Augusta, Georgia.
Bless you.
Okay.
And
Yes,
you
ma'am.
need to let probation know which county that is.
Yes, ma'am.
Ms. Abrams, if possible, field visits one time per month for 2 months. The court will find that restitution has been paid in full. There is to be 200 hours of community service restitution. Do you have any children?
No, ma'am, just the one on the way, and he's due next month.
All right, I'm gonna order parenting classes. Once those are completed, the community service hours are deemed satisfied.
Yes, ma'am.
There's $1,000 fine and that will be probated.
Okay.
Probation, is there anything else?
Judge, I heard you correctly saying 6 years deferred, right?
Yes, I'm so sorry. Yes, 6 years.
And that was 200 community service hours?
Yes.
Nothing else, right?
Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendants' Right to Appeal with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes,
With
ma'am.
regards to the trial court certification, the court will note for the record that the defendant was unable to sign the trial court certification of defendant's rights to appeal. All right, we can go off the record. And this court communication is key. You're going to be supervised by the probation office in Augusta, Georgia.
Yes,
You
ma'am.
will still need to follow their instructions and their rules. Do you understand?
Yes, ma'am.
If a motion to revoke is filed, what will end up happening is that you will have to come back to Bear County. Do you understand?
Yes, ma'am.
It's very important that you follow all of the instructions that are being given to you. Do you
ma'am.
understand?
Mhm.
If there is an issue, let your probation officer know in Augusta know. If you feel they're not addressing it, you can call probation here, and you can always zoom in and take it up with me if you feel no one is addressing those issues.
Yes,
So,
ma'am.
excuse yet. I'm going to send you to a breakout room. Probation is going to go over conditions with you. Once she's finished with that, then you can just excuse yourself from this Zoom, okay?
Yes, ma'am.
All right, good luck. Thank you.
Yes, ma'am. Thank you.
Most defendants walk into a plea hearing expecting a simple formality. They expect the judge to nod, stamp the paperwork, and move on. But in Judge Stephanie Boyd's courtroom, accountability is not a formality. It's a process. This hearing was a masterclass in judicial authority, proving that a sentence is only as strong as the oversight behind it. What the defendant expected. Anna Gifford came to court with a box checked. Restitution was paid. A plea deal was amended. She had her attorney, and on paper, everything looked clean. She likely expected a quick guilty and a standard probation term. The initial, almost casual banter about the court's computer system, Odyssey is down, suggested a routine day. But for Judge Boyd, the real work begins after the plea is accepted. What the court reviewed. As Judge Boyd prepared to sentence Gifford to 6 years deferred adjudication, she didn't just look at the charges, she looked at the context. The defendant lived in another state. The original crime involved financial fraud. Immediately, the judge's protective instincts kicked in. She didn't just order standard probation, she tailored it. The moment the defendant mentioned being a home health care provider, Judge Boyd saw a potential future risk. She didn't hesitate. There should be no employment as a home health care provider or with minors. The unexpected shift. Then came the pivot. The defendant mentioned she was due to have a baby next month. In many courts, this might just be a note in the file. For Judge Boyd, it became an opportunity for rehabilitation. Instead of simply ordering 200 hours of community service, a punishment that would separate a new mother from her child, she innovated. She ordered parenting classes and, upon completion, deemed the hours satisfied. This wasn't leniency, it was strategic intervention. She was addressing the root cause and ensuring the defendant's success by building a support system, not just a punishment. Why the final decision was inevitable. The final moments of the hearing solidified Judge Boyd's philosophy. She didn't just dismiss the defendant, she leaned in, issuing a stern warning that framed the entire sentence. If a motion to revoke is filed, you will have to come back to Bexar County. She made it clear that distance would not dilute her authority. By giving the defendant direct access to her courtroom if probation issues arose, you can always zoom in and take it up with me, she established a direct line of accountability. The final decision wasn't just about the 6-year term, it was about creating a structure so tight that failure would be a conscious choice, not an accident. Judge Stephanie Boyd's ruling was not about punishment alone. It was about forcing accountability, setting firm boundaries, and making it unequivocally clear that crossing the court has real, unescapable consequences.